Getting a divorce in Oregon is actually simpler than you might think. If the spouses were not married in Oregon, one spouse must be a resident for 6 months before filing. If the marriage was in Oregon and either spouse is a resident at the time of filing, there is no residency requirement. The divorce may be filed in the county where a spouse resides. There is a 90-day waiting period before a hearing is scheduled, beginning after the respondent has been served or the publication of the summons. An affidavit signed by both parties will waive the waiting period. Once the residency requirement is completed, a legal grounds for divorce must be established. Both general and no-fault divorce are acceptable grounds for divorce. The no-fault reason is irreconcilable differences between the spouses which have caused the irremediable breakdown of the marriage. Misconduct of the spouses will only be considered when child custody is an issue or, if necessary, to prove irreconcilable differences. The general reasons are consent to marriage was obtained by fraud, duress, or force, minor married without lawful consent, and spouse lacked mental capacity to consent, including temporary incapacity resulting from drug or alcohol use. Spousal misconduct is considered only when child custody is an issue. Oregon requires a parenting plan for child custody. Joint custody, joint responsibility, and extensive contact between the child and both parents is encouraged. Joint or sole custody is determined on the best interests of the child and the attitude of the child, the desirability of maintaining continuity, any spouse abuse, the relationship of the child with parents, siblings, and other significant family members, and the parent's interests and attitudes toward the child. Conduct, income, social environment, and lifestyle of the proposed guardian is considered only if it is shown to cause emotional or physical damage to the child. No preference is given because of the parent's sex. Final judgment must include health benefits. The court will not order joint custody unless both parents agree on custody. Either parent may be ordered to pay child support based on the ability of each parent to borrow, the parent's earnings history, the reasonable necessities of each parent, the physical, emotional, and educational needs of the child, the relative financial means of the parents, including their income, resources, and property, the potential earnings of the parents, the needs of any other dependents of a parent, any Social Security or Veterans benefits paid to the child, and any other relevant factors. Official child support scales and formulas are available. Child support payments may need to be made through the court clerk. Court orders may be issued to withhold wages for child support. Every child support award must also contain provisions for the payment of any uninsured medical care and health insurance for the child. The court may also order support to maintain life insurance coverage with the child as the beneficiary. Oregon is an equitable distribution state. All property is subject to division by the court, including gifts, inheritances, and property acquired before the marriage. Regardless, jointly or individually held property, it is presumed that the spouses contributed equally to acquiring any property, unless shown otherwise. All property is divided, regardless of fault, based on the cost of any sale of assets, the amount of taxes and liens on the property, the contribution of each spouse to the acquisition of the marital property, including the contribution of each spouse as homemaker, any retirement benefits, including Social Security, civil service, military, and railroad retirement benefits, any life insurance coverage, and whether the property award is instead of or in addition to spousal support. Either spouse may pay spousal support to the other spouse, regardless of marital fault. Oregon recognizes 3 separate types of spousal support. Transitional support, as needed for a spouse to gain the education or training to re-enter the job market or advance his or her job skills. Compensatory support, as needed to compensate a spouse who has provided significant financial or other support to the education, career, or earning capacity of the other spouse. And standard support, the amount needed for one spouse to support the other for a specific or continuing period of time. Each type of support has different factors to consider. Those factors consist of transitional support factors, the duration of the marriage, a spouse's training and employment skills, a spouse's work experience, the financial needs and resources of each spouse, the tax consequences to each spouse, and any other factors the court feels are just and equitable. The factors for compensatory support are the duration of the marriage, the amount, duration, and nature of the spouse's contribution, the relative earning capacities of the spouses, the extent to which the marriage assets have benefited from the contribution, the tax consequences to each spouse, and any other factors the court feels are just and equitable. For standard support, the factors are the duration of the marriage, the age of the spouses, the health of the spouses, including their physical, mental, and emotional condition, the standard of living established during the marriage, the relative income and earning capacity of the spouses, a spouse's training and employment skills, a spouse's work experience, the financial needs and resources of each spouse, the tax consequences to each spouse, a spouse's child custody and support responsibilities, and any other factors the court feels are just and equitable. The court may order the spouse to pay the support life insurance with the other spouse as the beneficiary. In addition, a spouse may have the right to continued health insurance coverage under the other spouse's policy. Either spouse or the court may delay the divorce for 45 days while reconciliation or settlement is attempted. In addition, if child custody or child support issues are contested, the court will refer the parents to mediation for up to 90 days. Visit us today at www.mydivorcepapers.com and click on Oregon at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.